All right. Hello, everyone. I'm Jenny Smith. I'm the Executive Director of West Virginia Rivers Coalition. And I'm so glad that you chose to press play and watch this today. This is a special conversation about something that's really close to my heart, how we can care for the places we love, not just for today, but for generations to come. At West Virginia Rivers, we're about more than just rivers. We're about the communities, the wildlife, and the people who depend on clean, healthy water every single day. We're the only statewide nonprofit focused on West Virginia waters, and we've been at it for over 35 years. We started out as a group of paddlers and whitewater lovers who wanted to restore the mountain state's scenic beauty. Since then, our mission has grown, but our values are the same. Clean water as the foundation of life and the belief that everyone deserves it, not just for recreation, but as a basic human right. We imagine a West Virginia where rivers and streams are clean and restored, where communities thrive in sustainability and shared prosperity, and where people celebrate their connection with the natural world. To make that vision real, we work to protect public lands, advance climate action, ensure clean water for all, and lead watershed advocacy across the state. And with that, I'm very excited to introduce you to our guest today. But before I do that, I just want to say a word about why this conversation on plan giving matters so much. Plan giving isn't just about financial planning, it's about aligning your strategy with your values. It's one of the most meaningful ways to ensure that rivers, streams, and communities you care about today will be protected and cherished long into the future. Now, let me tell you a little more about our guest. David S. Hugert, better known as Sam, joined Ray, Winton, and Kelly as an associate in 2011 and has been a member of the firm since 2017. He's a graduate of West Virginia University and a 2009 graduate of the Appalachian School of Law. During his legal career, Sam has practiced in a variety of legal fields, but currently concentrates in the area of domestic relations, guardianship and conservatorship proceedings, and estate planning, administration, and litigation. Sam is currently a member of the West Virginia State Bar and is admitted to practice law in the state of West Virginia and the Southern District of West Virginia. Now, I'm going to hand it over to Sam, who will guide us through the essentials of estate planning and legacy giving.
Thank you, Jenny. It's an honor to be here with West Virginia Rivers today. First, we're going to talk about certain types of estate planning. We have your medical power of attorney. We have durable and springing powers of attorney. We have documents creating a designated beneficiary. We also have trusts and last wills and testaments. First, we're going to start off with the medical power of attorney. A medical power of attorney is simply a document executed that states who you want to be your representative make healthcare decisions for you when you lack capacity to do so. As for what we call a business power of attorney, or just power of attorney for lack of a better word, all that is it's simply a document executed that states who you wish to be your agent to manage your property upon your death. Just manage your property. Now, there's two different types of powers of attorney. There is a durable, which a durable power of attorney does not terminate when the principal, which in this case, that would be you if you're having a power of attorney made for you, lacks capacity. The main thing to know about when you're signing a durable power of attorney is they're typically effective upon execution, which means as soon as you sign it, it is effective. The other type of power of attorney we're going to discuss is a springing power of attorney. Now, this type of power of attorney is effective only after the occurrence of a specific event. In my line of work, where we see it is typically when the principal has been deemed incapacitated. As for trust, the legal definition of a trust is a will of the grantor which is duly admitted to probate or a record signed by the grantor that contains terms of the trust, including any amendments thereto. Um, a more simple description of what a trust does essentially is when you create a trust, what you're doing is you're taking assets that are in your name and you're placing them into the name of the trust. Therefore, you no longer own that asset. It is an asset of the trust, which is managed by a trustee who follows the terms of the trust. As for the benefits of a trust can do several things, including a trust can potentially avoid probate, which is the process of uh, you know, turning in your will or trust to in Kanawha County, it'd be the fiduciary supervisor's office. Other counties, it's the county commission or whoever handles their probate process there. Because essentially, if no assets are in your name at the time you pass, well, you don't really need probate. Those assets are already in the trust. Therefore, they're not really a part of your estate under the laws of the state of West Virginia. Another benefit that trusts provide is privacy. Unlike last wills and testament that get recorded upon your passing if they are to be probated, a trust does not need to be recorded to be upheld. Sometimes you'll see what they call memorandum of trust recorded in a county, but the trust is very rarely recorded. Another benefit to trust is you have probably the greatest control over the distribution of your assets compared to, say, a will. And we'll get into a little more detail with that in a little bit. But what you see in trust, some people uh, they have concerns about, their children, siblings. Uh, don't see it as much with spouses, but usually it's with children that they have concerns with their children receiving assets until they reach a certain age, or sometimes they stagger it out to, where a child will receive a certain percentage of the trust at age 20, then 30, 40, whatever the grantor wants. They can control that through a trust. Also, trusts provide potential tax benefits depending on how they're set up. And lastly, one of the more important benefits to a trust is there can potentially be, depending on, like I said, the type of trust, protection against creditors and legal judgments. Again, like we talked about before, if an asset is not in your name and you do not control it, then if there's a judgment against you later on, and you don't have any assets, then basically the opposing party is going to have a piece of paper saying you owe them money, but no way to collect, which may be of interest to some of you. Now we're going to be talking about designating a beneficiary and what that means. Essentially, designating a beneficiary, all it is the process of naming an individual who will receive an asset upon your death. And we're going to go over a few examples of what types of documents those may be. For instance, we have bank accounts. A bank account can be held jointly with another person, and in the state of West Virginia, that creates a rebuttable presumption that when you pass away, the other person that holds that account jointly, those assets are theirs. Also, bank accounts can be made to be payable on death to others. Um, we also have retirement accounts. Retirement accounts have beneficiary designations. There's also stocks, bonds, mutual funds, and annuities. We also have life insurance policies, which most of you probably have through your employer, or you may have some private life insurance policies. One thing to keep in mind today is if you have an account that has a designated beneficiary, then your will is not going to control that asset. So the benefits of designating a beneficiary are the fact that the asset is not subject to creditor claims. Essentially, in the state of West Virginia, if you have a designated beneficiary on, let's say, a life insurance policy, well, in our state, as soon as you pass away, it is deemed to be the property of whoever you put as the beneficiary. Therefore, what you see a lot of times in estates is if someone passes away with a bunch of debts, usually we see credit cards sometimes, and they're usually not a big issue because they're maybe $1,000, $2,000. Sometimes there's some extreme examples, but other times, what we see is maybe some last medical bills. Maybe a person, they had an injury, they got in an ambulance, they went to CAMC and incurred a ton of medical bills that ultimately did not wind up saving their lives. Well, afterwards, when you pass away, that hospital that rendered care can submit a claim against your estate, essentially putting a lien against your estate and your property, um, that must be paid, or if there aren't, there's other ways around it. But essentially, the gist is they get paid before anybody else gets a distribution of your estate. Now we're going to get into your last will and testament, which a lot of you are probably familiar with, but simply a will is just a document that expresses an individual's wishes regarding the distribution of their property upon their death. There's basically two primary kinds of wills. There's one that's solely in your handwriting. We call that a holographic will. That is valid in the state of West Virginia. There's a few things you need to look out for, but essentially, if you have a will that's solely in your handwriting and you've signed it, then that is a valid will in the state of West Virginia. We also have written wills, and we're going to get into the requirements of a written will now. Essentially, to have a written valid will, you need to have a grantor. That's essentially the person that the will is being created for, and the person that's signing the document. They have to be at least 18 years of age and have capacity. Also, you need two witnesses present at the signing of the will, and you also need the witnesses and grantor to sign the document in each other's presence. The benefits of a last will and testament are as follows. The first one we see sometimes is you can nominate a guardian for your minor child. An example of that would be perhaps you're married and you have one child, through the marriage. Uh, what we sometimes do is we put language in a will that states that if my spouse were to predecease me, then I nominate and appoint a grandparent, one of your siblings, maybe a best friend, whoever to serve as guardian over my child upon my death. And the important thing to remember is this is not binding in a court of law, but it is used as persuasive evidence as to what the parent would have wanted. And typically, as long as it's in the best interest of the child, the court will likely appoint the guardian you nominate in your will to be guardian over your child. Um, Another benefit to having a will is you can choose who carries out your will. And we'll discuss what happens when you don't have a will in a little bit. But essentially, who's carrying out the wishes of your will is called an executor. Typically, we'll list two or three people, and the language will be something similar like, I nominate my spouse to be executor of my will. However, if for some reason she cannot serve or predeceases me or he predeceases me, then I nominate, and you can go down the list. And what we do is we just try to make it so that if one person cannot do it, you don't need a new will. We've got other people in place that can serve as alternates if needed. You can't necessarily do that if you don't have a will. Another benefit to having a last will and testament is that it allows you to make specific gifts to specific people or organizations where, we'll discuss in a little bit, but essentially, if you pass away and you do not have a will, then your family is just going to get a percentage of your estate. It does not distinguish who gets what, as in specific assets. It's just everything is divided up percentage wise. Uh, Another benefit to having a last will and testament is to some extent, you can control when the distribution of the estate occurs. Like we talked about in trusts a little bit ago, trusts, you have extreme control over distributions of assets. In West Virginia, we have a law called the Uniform Transfer to Minors Act. And under that act, we can restrict distributions up to the age of 21. So if you're worried about your kids receiving a share of your estate upon your death, and maybe they're a little too young to maybe really handle those assets at the time, you can delay it somewhat under a last will and testament. Another benefit to having a last will and testament is it can create a trust for you, which we discussed earlier, the benefits of having a trust and what it does. The last benefit we're going to discuss briefly today is the fact that if you have a last will and testament, there can be language in that will that waives bond for your executor. If there is not language in your will waiving bond, then your executor will have to post bond, and that bond will have to be covering essentially your personal property. Now, if you just have a couple $1,000s upon your passing, then the bond isn't that much. But when you start getting into more significant assets, into the, several 100,000 to several million, the bond can be quite high. And perhaps maybe your executor, because until they're appointed, they don't have asset to your, or they don't have access to your funds. They may not be able to post that high of a bond at that time. And there's other ways around it, but that's one of the last benefits we're going to talk about today regarding wills. As we kind of talked about in the last slide, but we'll go over in a little more detail now, is what happens if you don't have a will? Well, essentially, the assets of your estate are distributed pursuant to the law of intestate descent and distribution. Um, the important thing to know about this is essentially there's three scenarios that can play out under this circumstance. If you have a spouse, and let's say you have two children through the marriage with your spouse, and neither of you have other children. Under the laws of the state of West Virginia, your surviving spouse would receive 100% of your estate. Whenever one of the parties has children outside the marriage, it gets a little more complicated. For instance, if the decedent, which is the person that just passed away, if that spouse had a child outside of the marriage, then automatically the surviving spouse's share of the estate gets cut to 50%. Um, One other example regarding intestacy is, let's say all of the decedent's children are children of the surviving spouse, but the surviving spouse may have one child outside that marriage. Well, under that example, the surviving spouse receives 60% of the decedent's estate. So if you want to have absolute control of who receives what under your state, you really need a last will and testament. Otherwise, you're stuck with the laws of the state of West Virginia, which you may not like. Um, a, Another example of what happens whenever you don't have a will is basically anyone can serve as administrator of your estate, including creditors. And what the administrator is, it's exactly, it's pretty much exactly the same thing as an executor. It's just the fact there is no will. They just have a different title. Um, but without a will, you don't get to designate who carries out your estate. So you could potentially have a credit card company who's a creditor because they are interested party distributing assets pursuant to your estate, which you may not care for. And lastly, uh, one other instance of what happens without a will is essentially a bond is always required. And like we said before, it would have to be for the personal property of your estate, which could or could not be a very significant bond premium depending on how many assets you have. At this point, hopefully you're asking, how do I get started with my estate plan? Well, the good news is if you're just needing a durable power of attorney or medical power of attorney, there are standardized forms that have been approved by the state of West Virginia. You can find through the state bar website. They are provided in the West Virginia Code. You can also perform a search for those online. Uh, when it comes to wills and trusts, there are some online companies that they do offer those services. I just don't have any experience with those companies because this is what I do for a living. And last but not least, if you need help with estate planning, please contact an estate planning attorney. How do I create a charitable bequest? The most important thing to remember here is probably please identify the correct name of the charitable organization that you wish to give to. There's several organizations out there that have very similar names or maybe the same names but with a different ending such as incorporated or company, association, whatnot. If you do not have the correct name, there could be some confusion of who receives your assets when you pass. What we would recommend you do, there's two good resources available to you through this state. One's the IRS. You can go to the IRS website, which we've provided a link for today. Click on that link. It'll take you straight to a search for all charitable organizations recognized by the IRS. Another good resource for determining if you have the correct name for the charity you wish to give to is you can simply log on to the West Virginia Secretary of State website, which we've provided a link for as well. So now we're getting into the last part of the conversation today. But if you're wondering, how do I name West Virginia Rivers as a beneficiary? It's real simple. When we're dealing with retirement accounts, life insurance, or any other policies that uh, have a beneficiary designation, you literally just have to put the correct name of the organization, which is, I believe, West Virginia Rivers Coalition Incorporated. You put that down as the beneficiary. Uh, there, one thing to consider is typically on these types of forms, there is a primary beneficiary, which is the first person or organization that you'd want to receive that asset upon your death. Or there's also what we call a contingent beneficiary. If maybe the primary beneficiary has passed away, or maybe that organization you want to give to doesn't exist, you can list West Virginia Rivers as a contingent beneficiary as well. Another example would be, let's say you're married. Maybe you have your spouse as a primary beneficiary of a life insurance policy. Well, if under the unfortunate circumstance that your spouse predeceases you and you've done nothing else to this life insurance policy regarding beneficiary designations, then that asset upon your death is going to go to your contingent beneficiary, which could potentially be West Virginia Rivers. Also, well, I guess we kind of already discussed this, but conveying ownership of a life insurance policy to West Virginia Rivers, which I can talk about some examples regarding that in a little bit. But the same thing goes for all the accounts above: retirement accounts, life insurance, um, any account that has a beneficiary. If you want to give to a charitable organization, just make sure you have the correct name and put them down as either the primary or contingent beneficiary, whichever your preference is. how do you include charitable organizations such as West Virginia Rivers in a trust? There's typically two types of trust out there. There's a remainder trust and there's a lead trust. If you have a remainder trust, essentially what you're doing is you're stating that West Virginia Rivers receives what's left of your estate or of the trust assets after your loved ones have been cared for. A simple example would be if you have a trust for the benefit of your spouse. You can have language in the trust that says, upon the passing of my spouse, I want the remainder of the trust to go to West Virginia Rivers Coalition Incorporated. There's also, like we said, there's lead trust, and that's where you can list a charitable organization to receive the benefits of the trust up front for a period of time. And then you can list other remainder beneficiaries that would receive the benefits of the trust after a certain period of time. An example would be you could list charitable organization to be beneficiary for let's say 10 years. And at the end of that 10-year span, then your trust could pay to other beneficiaries as you so choose. As for providing bequests for or devises or bequests to charitable organizations under a will, um, you can leave gifts to charitable organizations such as West Virginia Rivers by donating a specific amount of money, a percentage of your estate, or a specific asset to that charitable organization. Um, you can also put restrictions on the asset you are giving to that charitable organization by either making it restricted or unrestricted. We'll get into some language of what you might see in a will in the, I believe, next slide. An example of how to include West Virginia Rivers in your will or any other charitable organization is as follows. Basically, you can state that if my son does not survive me, I give, devise, and bequeath my residuary estate as follows. My West Virginia Consolidated Retirement Plan to West Virginia Rivers Coalition, Inc. for its general charitable purposes. And as we mentioned in the last slide, you can also leave a specific amount or a percentage to a charitable organization if that's what you would prefer. Now we're going to briefly talk about the benefits of giving to charitable organizations. One thing to consider is your donation to a charitable organization may be considered tax deductible, reducing your taxable income. Um, Charitable organizations such as West Virginia Rivers do not pay income tax, so your gift goes further. Uh, as for retirement accounts, if a retirement funds like your IRA or 401k go to an individual, they usually pay income tax. However, if you give to a charitable organization such as West Virginia Rivers, they pay no income tax for that gift. So, in essence, um, more of your asset goes further when donating to charities as opposed to individuals. Um, when you make certain bequests to charitable organizations, you can also qualify for tax deductions for your gift. If your donation is larger than what you can deduct in 1 year, because the IRS does have policies and there are age limits and when you can do this and how much you can give. But essentially, what you need to keep in mind is if you want to give more than what you are allowed to by law, there may be ways around that to where the deduction be carried out over several years. Another example of um, giving that we've kind of talked on previously is for a life insurance policy. One example of what you can do is obviously you can designate West Virginia Rivers as the beneficiary of that policy. But what you can also do is you can make West Virginia Rivers or another charitable organization the owner of that policy, which gives you a tax deduction when you transfer the ownership of the policy to the charitable organization. And if, for instance, maybe, um, let's say there are some, you know, monthly dues still needed on that insurance policy, what you can do is you can donate the amount of that premium to the charity each month, and that can also be included as potentially an income tax deduction at the end of each year.
Okay, well, I want to thank you guys so much for continuing to spend time with us today. And now I want to introduce you to someone who's already taken this step and including West Virginia Rivers in his giving. Doug Evans is a supporter, and he will share in his own words what inspired him to make that decision and why this gift matters to him.
Hey, what's going on? Doug Evans here. Listen, most people don't think about plan giving until it's too late. I've been a fundraiser for a while, and that's probably why I've kept my estate plan in pretty good order. I update it pretty regularly. Most folks obviously don't. Usually, the first time they even think about it is when they have a kid or they get married or life throws you a curveball. But here's the thing, I've always challenged people to think about what they have to give. Most of us have something we could give. Many jobs come with life insurance. I tell young people all the time, take 5 or 10% and give it away. Not because you have to, but because life has given you a lot. And plan giving isn't just about charity. It's about family planning too, thinking about kids and grandkids, college tuition, and moments when you can give a loved one that lift during a hard time. For me, though, when I think about what matters, it always kind of comes back to rivers. I grew up playing in the Holly River and the backwaters of the Elk. In summers on the New and the Gully, watching kayakers fight their way through every hazard you could imagine. I went to Marshall University and lived in Parkersburg, West Virginia on the Ohio. Worked at the ACLU where the Kanawha meets the Elk. Drove the back roads to float the coal in the tug. Water has shaped my whole life. And to paraphrase Tolstoy, people are like rivers. The water is one and the same in all of them, but every river is narrow in some places, flows swifter in others. Here it is broad, there it is still, or clear, or cold, or muddy, or warm. Everyone bears within themselves the germs of every human quality, and now manifests one, now another, and frequently is quite unlike themselves while still remaining the same person. That's why rivers speak to me. They're a mirror for who we are, always moving, always changing, and still the same at their core. And that's why I believe so deeply in West Virginia River's work. It's not just about loving the beauty of a wild stream, it's about science. Good science in good trouble. Science that measures the health of our waters, identifies threats, and gives us the data we need to hold leaders accountable. And it protects what we can't afford to lose. In a world where feelings and opinions often get more airtime than facts, West Virginia Rivers leads with science, and that matters. About 6 months ago, I had a heart attack. I'm okay, but moments like that certainly give you pause for reflection. You ask, what am I doing? What am I leaving behind? And in a world that's changing this fast, those questions can feel even heavier. The last couple of weeks, I've been traveling around collecting stories and snapshots of life in the hills, hollers, and places I've called home. I'm reminded that President Kennedy once said, the sun does not always shine in West Virginia, but the people always do. I live in North Carolina now, but that still very much rings true. West Virginia Rivers, its people, its resilience. They've carried me my whole life. And leaving part of my estate to West Virginia Rivers is one way I can carry that love in my heart forward long after my physical one stops. So if clean water matters to you, if rivers have given you joy, peace, or memories, think about what you can give back. West Virginia rivers will be around long after we're gone. For me, this gift is just a way to say thank you to the rivers that have shaped me and to the people and places who have always shined. Thank you for all you do.
I'm so grateful to Doug for sharing his story. And again, I want to also thank you for your time and listening to today's presentation. And I want to thank Sam as well for sharing his expertise with all of us. On behalf of all of us here at Rivers, I want to thank you for being a part of this work and for considering how your legacy can make a lasting difference. We can't do this without you.